This program is made possible by the New York law firm of Zalman and Storman, who specialize in the field of personal injury law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now we introduce our guest and our host, Alan Schnorman.
Welcome to Lawline. Should adoption laws be nationalized to prevent the tragedy of baby Jessica from happening again? What are the rights of the birth parents versus the adoptive parents? Should the courts take into consideration the best interests of the child when making a decision? These are some of the questions we'll answer today with our guests. The Honorable Bruce Kaplan, Family Court Judge, New York County, and Erin Britvan, an adoptive attorney who is also an adoptive parent and is also whose daughter is practicing with him in the practice now, who's adopted. Erin is co-chair of the Adoption Committee of the New York State Bar Association. Hello, Judge Kaplan. Hello, Erin.
Hello, Good evening.
Alan. Good evening. Erin, give us an idea about the baby Jessica case. What was that about, and how does it affect us here in New York?
It's amazing that when that got such national publicity, my office was getting calls from a lot of concerned clients. And what I had to explain to them is that it doesn't affect New York.
Tell us about the case. Give us a little background.
Basically, it was a situation where it originated in Iowa. And Iowa's laws are rather stringent in that they really look and favor birth parents' rights. They give them a superior right. When the baby Jennifer case, the birth mother and the initially an alleged birth father signed the consent. After the birth mother's rights were terminated, she then brought in another name of a birth father.
A different person.
Different person.
Interesting.
And
he established paternity.
Well, the point is, he did. But
and
when
this was when the child was, what, 2 or 3 weeks old?
No. It was 2-3 weeks old when the allegation was made that there was a different father. The point,
His consent would be needed if indeed he was the father.
if he was the father. The point here, of course, is the Boas have custody of a child. I know, and any adoptive parent knows, that when you take custody from minute number one, you love that child. Now, it's possible that presently Ms. Schmidt, who now names somebody else, we did not know, or they did not know, whether he was really the father.
But Erin, what I don't understand is the case went on for years.
Because of the appeals. In other words, what happened...
But still, here the adoptive child has that child in their home. The adoptive parents are giving the child all their love, all the care, all the nurturing, and then 2.5 years later, they give up the child?
Well, the interesting thing here is that the couple was residing in Michigan. The DeBoas were in Michigan. They adopted the child born in Iowa, but they were from Michigan.
Right.
In Iowa, it was determined that the birth parents had the rights.
And it was in Iowa that the DeBoas got the child.
No, it was.
And this is the difficulty about the situation. Generically, New York law, every state's law says just because someone's got the ability to keep things going and at the same time keeping the bond burgeoning, expanding, they were on notice from the get-go. Hey, you've got a problem here. Now, there is a debate. There are few things more touching in family court, which is a palace of sorrows, than the moment that I grant an adoption petition, as you know from the many times you've been there with your clients when I've done that. The sense of joy and fulfillment that an adoptive parent has, I can only empathize with, you can speak to. But the bedrock of our constitutional law is that the family, the natural parent, has a preeminent right. And that right should not be gainsaid because someone could do a better job. I would say 99% of the time, an adoptive parent is going to give a child a fuller, a better, a more indulged, a more luxurious life. But these aren't chattels, these are children, and that's why the safeguards at the beginning have to
To some
be
extent,
there.
I have to disagree with the judge.
Okay.
Basically, even in New York, we had a baby Jessica case in 1971. It was a case of Scarpetta versus Spence Chapin.
Right.
And as a result of that case, because there was in New York a superior right under the statutes and under case law before 1971, in 1972, New York State Legislature changed that law.
That says?
That says basically once a birth mother or birth parent signs the consent, they give up the absolute right to get the baby back. They give them a window of 45 days in which they can attempt. But then, if they attempt, the criteria in New York is the best interest of the child. That is not the case in Iowa.
Let's take a summary now. There are birth parents and adoptive parents. The birth parents say we don't want the child for one reason or another. We're both adolescents and we can't afford the child, or we're not ready to nurture a child, and they give up the child. They have how long? 45 days after the adoptive parents have the child?
To attempt.
Judge?
To revoke their non-judicial consent.
Attempt to revoke.
Yeah, to give notice of doing it. And, here's what happens. As the law evolves, you mentioned the 72 statute. Let's look at some of the more recent ones. Before a consent is taken, either out of court or certainly in court, that birth parent has the right to be represented by counsel of their choosing, who's representing them, not the adoptive parent, can let them know what's going on. There are horror stories of someone coming out of the recovery room, and maybe they don't have the best history either, and the paper's put under their nose.
Right.
And they have then surrendered their child, or used to before these...
New York has addressed these things.
Aaron,
Yes.
so does that mean that even though this 45-day rule is not hard and fast, that if the consent is given and it's not a knowing consent, you can bring an action later on?
Oh, absolutely. The point of the statute is that you have 45 days absent fraud, coercion, duress. If there is any fraud,
Which is
coercion,
done-
duress, then it can be set aside.
Again, and also there's statutory requirements for how a consent can be given both in court and out of court. Now, one of the reasons we were bringing in birth mothers 2 and 3 weeks after giving birth to say in front of a judge represented by counsel, yes, I do want to give up my child, is that for years there was a distrust of what went into getting the non-judicial consent.
Judge, let's assume right out there in their living room, in their kitchen is a couple. They're seeking to adopt a child, or they're thinking about adopting a child. Certainly they don't want to adopt a child and then have to give the child back. I mean, they don't want to have a child in their home and love the child, fall in love with the child, and then all of a sudden have that child pulled out of their home. What is your advice to that couple to protect them?
Consult Mr. Britvin.
I understand that. But what,
And I hope we have Judge
that's the easiest.
Again,
what should they do to protect their interests?
what they seriously should do is not to make any moves, because there can be some very hairy situations that arrive, without consulting counsel. The aftermath of the Steinberg case was that before people can take a child for the purpose of adopting, is they have to be certified as qualified adoptive parents. They're not supposed to take a child into their home unless they have that certification.
Where do you get that certification?
Through the court.
Through the court. There is a procedure under the domestic relations law that provides for that. And a lot of people don't quite know. They make contact, they advertise, they listen to what their friends do, they haven't consulted counsel, so they don't know what the prereqs are. And those people are in mortal risk of having that child removed, because the child's there, they haven't done anything, they come to counsel and say, gee, I saw you on the law line, and we've had this wonderful little girl in our house about 3 days now. We want to adopt her. We want you to do the adoption. Have you been qualified as adoptive parents? What's that?
I just had this case. I had a situation where a baby was brought up from Florida without complying with another aspect of the law, which is the interstate compact. The papers in adoption today under the law have to be filed within 10 days. They've had the child for 3 months, and no papers were filed. They were never certified. Their lawyer, who was in a different area of practice, did not know what was going on.
What happens then?
Well, here you can file the papers, but the birth mother is going to get the baby back because she did come.
Birth mother will
Absolutely,
get the baby
because
back?
the law was not followed.
She had no right. They had no right to this child. Anything the birth mother did or didn't do doesn't matter, because, again, 99.9 times the people who are taking children are wonderful people. But if there are 1,000 adoptions and there are 10 bad apples that would have been uncovered if the law were followed, how many leases do you want?
But Judge, let me see if I understand this. I'm a parent and I'm going to adopt a child. And let's assume I place an ad in the newspaper and a young girl from New Jersey answers the ad and she says, listen, I'm an unwed mother. If you help me out with my medical bills and the expenses, I'd love to have you adopt my child. And I do all that. I help her out with her medical bills. I pay for the hospital. And I pick up the child at the hospital.
Excuse me.
Yes.
Without trying to make this promotional, I think as the judge alluded to, nothing should have been done without having counsel, legal counsel. And as the judge indicated before, it's both the birth mother that needs independent legal counsel and the adopting couple needs independent
legal counsel. In other words, both, well, let's assume the birth mother has no money, which is often the case.
Under the law, the adoptive parents can
parent
pay.
has to fund, although their lawyer cannot be...
representing both?
Both. I mean, the battles we've had about in California, this is perfectly okay to do both.
In other words,
and they would do it, and I'd reject the consent because there was not independent counsel. Bring the woman into New York to say in front of me.
So in other words, my wife and I should literally go out and fund and get an attorney for the birth mother.
You're going to get yourself in trouble if you don't. You really don't. Because, my opinion is that the New York adoption laws per se, and I will say this in all candor, I think are very simple. But if you don't know what you're doing, you can destroy lives.
Aaron, how long do my wife and I have to literally sit on tenterhooks, worried that the birth parent is going to give us a call and say, I want the child
The chances are, and I'd like to bring this out, Alan, the chances are you should not be on tenterhooks. The norm is that you will be. But I want to bring out a point, and that is that the DeBoa case, baby Jennifer case, is only one case which got a national attention. All right, and I always equate that like with an airplane crash. Unfortunately, when a plane crashes, it gets attention. When a plane lands safely, it is no attention. When we hear a custody battle, it receives attention. We don't hear about all the adoptions that take place without any problem. The point is we don't want any crashes. We don't want any problems. Technically, the birth mother, birth parent, has 45 days within they can seek to change their mind, absent fraud, duress, or coercion, but during that period of time, if they do attempt to change their mind, the best interest of the child comes into play.
There's going to be a hearing, and so-and-so who may have had an enlightened social history, may have had some recreational drug use, may have had a family history of some very unfortunate things, is going to be arrayed against two people who are committed or a single parent, because there are single-parent adoptions in New York, who has, from the word go, and one can demand the trial, one doesn't get it the next day.
Judge, I understand, but again, that's the best interest of the child.
Yes.
However, in the example that we were talking about, if the birth mother, if there's fraud, coercion, or duress or something, and the birth mother says, I was under such duress at the time, I didn't know, I didn't have any money, I didn't have anywhere to go.
That is not duress. That is not financial duress. It's really some fraud.
This is, I'm going to run an ad in the paper saying you were having illicit relationships with 10 married men and this drug addict father, or I'm going to just say, place an ad in your church bulletin that Mr. and Mrs. Jones's daughter Cynthia just gave birth to a lovely boy out of wedlock, or we're going to try and report you to the Child Welfare Administration.
You mean threatening the person unless you sign this document?
Or saying, how would you like an all-expenses 2-month holiday to our condo in Maui, new outfit?
I know years ago, when I was first practicing law, and I don't want to tell you how many years I started ago, you used to hear that couples would literally buy a child and would pay tens of thousands of dollars. Does that still go on?
One always hears about the gray market, and I cannot remember. I've had the adoption term for the last year in New York County, and I've had it over in my 16 years several times. I've yet to see a situation where that happened. Because if it does happen, no one's going to put in affidavits about it.
I think what the judge is saying, obviously, is it's not done openly. But I will tell you I'll have to say it's hearsay, because I have an obligation to report this to the grievance committee when I find out it's appropriate. There are bad things happening today, and it deals because people are desperate. Not because it should happen, because people are desperate.
We got to take a break now, but right after the break, we'll talk about those bad things. I'm Alan Schnorman, your host. You're watching Lawline. Stay with us.
After dating the guy forever, you think I could tell him anything.
Why is this so hard? I'm really scared.
It takes a lot of guts to tell someone he's too drunk to drive. But you can do it. Just say it. Because if you don't, there may be nothing left to say.
Kevin, I'm gonna drive.
Take the keys, call a cab, take a stand. Friends don't let friends drive drunk.
When your employees train with the National Guard and Reserve, they learn to be better team players, better decision makers, and better leaders. It's training that makes them better at serving our country. And better when they come back to work for you.
Bill's back.
Be a hero. Give your employees the freedom to protect ours.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're talking about adoption. Our guests are Judge Bruce Kaplan of the Family Court in New York County and Aaron Britvan, an attorney who specializes in adoption. Right before the break, Aaron, I had asked you about this gray market, and you're going to tell me about some bad things that you have heard goes on. And what are
people
those?
cover themselves. In other words, there are people out there that will, because of misinformation or desperation, pay expenses beyond what the law will allow. And
That's not the real part of the nasty. It's the big bucks under the table.
No, that's what I'm talking
Yes,
about. I'm
yeah,
saying they're
it's-
paying monies which are not being reflected to the
They're
court.
not. They're not talking about. They're not giving their affidavit of
But
financial.
it's happening because of desperation and misinformation. The misinformation being that there are no children out there to adopt, and that's misinformation.
Give us an idea. What are we talking about where the birth parent requires...
Sometimes it's not the birth parent. Sometimes it could be, with all due respect to my profession, I'm not here to, it could be the attorney that's involved.
requiring tens of thousands of dollars
Well,
or
we're
a
not going
large
to talk. We're going
number.
to not talk tens of thousands, but there can be adoptions that are costing $20,000, $30,000, which, if reflected in the court papers, would not go through. What people
Now, isn't
don't.
that unethical for an attorney
No.
to do that?
Absolutely.
Not only unethical, it's illegal.
It's illegal, but the
And you
point-
know how one finds out about it? One of your clients comes in. And
Not one of my clients.
No, and says to you,
One of-
"We lost this child."
That's
We
only
were gonna-"
after the fact.
Yeah, because someone in Texas all of a sudden came out of the blue, and the birth mother preferred them.
You see what
I mean,
happened?
that's the kind of
There are
anecdotal-
gimmicks, but also the problem is that if
Really?
someone does get a baby from an illicit source, and they pay $20,000, $30,000, they're not going to hang that person because they feel that person is a god. If they got a baby, that person is a god. I tell my clients that if you think anxiety is waiting to get a child, there's no greater anxiety than doing something beyond what the court allows and then the court finding out about it.
What happens?
The court can set aside the adoption. They're not looking to do anything to the child,
You could
but they
set
can.
aside where
Oh,
did the child go then?
Foster care.
This is a horror show. I mean, the child could then be placed. This happened in Nassau. They put a child back in with the Commission of Social Services.
They
those were
could.
people
As
who,
opposed to
who,
the adopted
abandoned their
parents?
adoption.
No one, again, Alan, is looking to hurt the child. What I'm trying to do, and maybe it's a scare tactic, but I mean it, people should not deal that way.
How do parents, again, that same couple sitting in their living room, sitting in their kitchen, they want to adopt.
What they should do
What should they
first,
do?
you know what the first thing they should do? Is get involved with a support group, an adoption support group. And there's some fine groups out there where
Where do they locate them?
they're in the telephone book, Adoptive Parents Committee, State of New York, there's an infertility
Adoptive
group.
Parents
What about New
League
Jersey,
and-
Connecticut? We're seeing all through
They're all
Jersey,
over the
Connecticut.
They're all
No,
over. Resolve, which is an infertility group, which also touches on adoption.
I
And they,
told you-
they go to meetings and then they...
They'll go to the meetings. They're going to hear things. They're going to be led in the proper
Aaron, what's
direction.
this I read about you should take ads out in
That's a common
newspapers?
thing. That's something
But
which has been
that's-
going on for 10, 12
Yeah,
years already.
but that's after you're certified as a qualified adoptive parent.
Isn't that interesting? You must be first certified.
Well, you should. You
be.
can take custody.
Yeah, you should be.
You
And
can
a lot-
advertise, but you cannot legally take custody unless you have a conditional certification.
Judge, let me ask you this. Let's take, again, the birth parents, take an instance of a young girl, and she gives birth, it's unwed mother, and she wants to give up the child, and all of a sudden the father, the unwed father says, no, I don't want to give up the child. I'll take the child.
Well,
What
there's a
rights does he have?
whole bunch of finely nuanced statutes recently enacted and not so recently enacted that talk about leading cases. Being a parent is more than the fact of biology. You have to be doing things. You have to be interactive. There are two sets of rules, one for a child surrendered out during their first 6 months, and then one thereafter. And the domestic relations law, I think it's section 111A, deals with what rights
does the unwed father have?
Well, if he has acknowledged the child, if he has been named on
Signed
the
the
birth
birth
certificate,
certificate.
if she has used a sworn statement naming him, if he has lived with the child and furnished support, if he has visited regularly, then he's got plenty of rights.
But let's take the
An adoption was just reversed by the appellate division this week because a judge did not recognize the rights of a non-marital father and said his consent wasn't necessary and he couldn't block the adoption, and the appellate division said the statute says A, B, and C, and he qualified, and you should have had a hearing to see whether he abandoned the
But
child.
every case is unto itself, because the Court of Appeals has ruled as of last year that even where there is a birth father did not know that the woman was pregnant and found out, he had no right. He has constitutional rights, but they weighed that against a child's constitutional right of permanency, and the adopting couple was able to keep the child.
There's an interesting thing there, because Judge Titone in his dissent took exception to the fact that this guy hadn't checked out to see this woman he'd been sleeping with for a long time, and he left her.
I don't want to get involved in dissents or anything. I just want to see if I can get the law out there. The question I have for the both of you
bottom
is,
line.
bottom line,
If the unwed father has shown an interest in the pregnancy or the child,
as defined in the statute, I mean, there's
well,
several criteria.
if there is anything, if they've, if there is some indication, you better get his consent.
You better get his consent.
Yes.
And if you don't get his consent, you take
You
that
can
under
upset
Have a consent, then you can have a contested hearing saying his consent isn't necessary because he abandoned the child, and that's something else.
But again, advising people looking to adopt, you do it by the book. You're not there to take custody and worry about what happens later. If the thing is not perfect, it wasn't made to be.
What about agencies? Going to agencies?
Agencies are not performing, really. Agencies are more geared, unfortunately, to the foster care system, which is another story completely in New York State and New York City.
What we're talking about, an unfortunate cradle-to-grave syndrome of 12-year-olds having children, being found neglectful, being delinquent, having these kids come into foster care, having the parents not get it together about trying to get the kid back, having their parental rights terminated. By this time, these agency children have been in what's identified as a pre-adoptive home for a number of years, typically. And when the parents' rights are terminated, it's overwhelmingly likely that these foster parents, who are in addition pre-adoptive parents, are going to adopt. And these are people coming out of a strata where there are a lot of problems. You're dealing with people who have backgrounds of drug dependency, of learning disabilities, of long-term dysfunctional, multi-generational families that are dysfunctional. And there's a two-tier adoption scheme that goes on. One are the kids who come into foster care as a result of neglect, whose parents' rights are terminated, and then the agency arranges to have these kids adopted by the foster parents the agencies has certified. Now, all the things we've been talking about before don't come into play.
It's a completely different area.
Aaron, what's the story? I keep hearing people sometimes, they go down to South America, they go down to Colombia.
That's international adoption, but I'll tell you, even with international adoption, you have to be very careful. Romania became very big, and there was black marketeering in Romania. So you have to be careful. I always say...
Tell me, what do you have to be careful about?
That you're not laying out lots of money. If something seems too good to be true, it probably is too good to be true. A woman out in Suffolk County was indicted. She was appeared on 2020 as a saint, but when push came to shove, she was indicted because she was taking money from couples as a source with Romania, and no one was getting babies. The point is, no matter which avenue you go, independent adoption, which can be legal, international or agency adoption, unfortunately, adoption can be big business. And you have to know who you're dealing with. And you don't go and take a baby for the sake of taking a baby, because everyone, as I'm concerned, that is looking to adopt will be successful.
Judge, what's the story now on surrogate parenting and surrogate mothering?
Well, New York has a new statute that does not allow someone to be compensated for doing this. This is something that, with all the problems we have, here's an area which is so emotional, and yet how many cases are there in the country? 500?
But in other words, in New York State, can I, my
monies
wife
can be-
and
no-
I...
No monies.
No money's you can't pay compensation to someone to carry
any
the child.
compensation?
No,
None.
You can pay the medical expenses.
Yeah.
Like any adoption, but otherwise you cannot give a woman, like in the past, it was give her $10,000 for carrying the
Well,
child. Cannot be done.
I know, I remember reading a case in Long Island where a surrogate, I guess...
A surrogate mother. And the father, you see, the child has
You know
two
the case?
parents, yeah.
Surrogate mother, and they actually had sexual relationships on more
Yeah, but
than
the
one
point
occasion.
there is that became a custody battle.
Yeah, I mean,
between
he's
two
the father.
individuals.
He's the
In other
father.
words, he is the father.
She's the
she
mother.
gets
So
So that had
visitation.
nothing to do with surrogate.
Oh,
It does, but there was no compensation.
No compensation, and he got custody.
Best interest.
Yeah, he had they made an agreement that he and his wife would get the child at birth.
Okay, Judge. Same example. My wife and I, we decide we don't want to adopt. We're going to go the surrogate parent route because my wife can't have a child, but I'm fine. And then I
You make the
retain this
arrangement, yes.
woman,
If
and
you can get
she's artificially inseminated.
If you can get your wife's sister to be the carrier without compensation, it might be okay.
It's not
We've
gonna
seen that
happen.
happen. Well, then it's
It's
not going to
not
happen
gonna
because
happen.
most
If
surrogates
I
are
can't-
looking for compensation.
Of course, well,
the law doesn't allow it.
The woman's going to carry for a number of months, go through all the turmoil
No one
of a
is saying it has
pregnancy,
to-
go through birth, which is, my wife explains it to me as pulling your lip over your forehead.
Well, I'll tell you, Judge Glenn once at the Matrimonial Law Committee meeting, not so facetiously suggested that minimum wage, 24 hours a day for 9 months should be an appropriate compensation for surrogate mothering.
Except for one
No.
thing, it doesn't establish best interest because
Yeah.
a surrogate contract, even before it was outlawed in New York, was not a
What
binding
about
contract.
New Jersey? Can you have a
No,
surrogate?
Baby M case.
Yeah,
That's where it all started,
That's where
the
it
Baby M
started.
case.
So basically, surrogate parenting, unless you can get a relative,
Or an
Someone-
altruistic, or the rare altruistic
gonna happen.
person.
it's not going to happen.
Yeah. No.
It's, so in other words, that really
But I'll
issue
say
is-
something else. It's an interesting
dead.
thing. You know, I'm an adoptive parent. I'm also a biological parent. And I don't condemn anyone no matter what route they go as long as it's done legally. But I think many people who proceed with surrogate parenting is because of their need, and they need some genetic connection. I don't think they can appreciate the fact that no matter how the child comes to you, you're going to love it from day number one. But I think it's because of the genetic connection. A lot of people in the past have sought surrogacy.
Worse than a genetic connection are the people who are the perfect couple with the co-op on Park Avenue, the place in Southampton, the ski chalet in Aspen. But they're out
Sounds
of it
good to me.
because they don't have a child at one of the 10 schools, so they can interact with their friends and do the parent things, and they want a vanity child. And they want a child so badly, and they'll do
Right.
most anything to get it because that completes the way they are as parents.
And the bottom line,
The bottom line is, when the kid doesn't work out to their expectations, they put the child in voluntary placement, and that's reprehensible.
oh my God.
I mean,
and
so
with
it's not only a
that-
genetic connection, it's a completing my lifestyle expectation thing. This is extraordinarily rare.
Certainly, if you want to adopt a child, I think we've learned how to do it today. Aaron Britvan, thank you very much.
Thank
Judge
you, Alan.
Kaplan from the Family Court in New York County, thank you very much for watching Lowline. And as always, this is Alan Schnorman, and thank you for watching Lowline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program is made possible by the New York law firm of Zollman and Schnorman, who specialize in the field of personal injury law, located at 63 Wall Street in New York City.